SJC-13209, Vermont Mutual Insurance Company, v. Paul Poirier.
Attorney Hepner.
Morning, Your Honor. Members of the panel, may it please the court, Peter Hepner for Vermont Mutual Insurance Company. I respectfully submit that when the established rules of policy construction and the canons of construction are applied to the interpretation of this policy, those rules compel the conclusion that there's one instance and one instance only where attorney's fees of another party are covered. And that's when the insured contract exception found at Record Appendix page 70 are satisfied. That exception is clear, that language is clear. Solely for the purposes of liability assumed under an insured contract, reasonable attorney's fees incurred by or for another party other than the insured are deemed to be damages because of bodily injury, tying directly back to the language at issue in the insuring agreement.
Counsel, can I ask you to take a step back? Was
Yes.
this the defense of this case tendered to the insurance company from the onset?
Yes.
It was. And so in some ways, the insurer controls the attorney's fees expended by the plaintiff in this case.
By the plaintiff, there's a contest, absolutely.
Yeah.
And it was a contested case all
And
along.
so tell me this, how is it fair or reasonable for somebody who's the insured, who complies with her obligation to tender the defense to the insurer, to then be on the hook for the reasonable attorney's fees expended by the plaintiff who the insurer decided to fight?
Well, the counsel is defending the insured, not the insurer. The insured can appoint counsel, can select their own counsel, or they can accept counsel that has been appointed by the insurance company. When there's any type of a possibility of non-coverage, the insured has the right to select their own counsel or go with an attorney that has been selected by the insurance company. And that attorney represents the insured, not the insurance company. That attorney is communicating with the insured. And
So who
defending the insured.
decides whether or not to make a or a 93A settlement offer?
I think both or either.
No, in this case.
There was a small offer made in the beginning of the case by the insurance company.
Okay. And that was rejected.
They filed suit instead of accepting the offer,
Yeah.
yes.
So in some ways, it's the insurer's fault that there were these reasonable attorney's fees awarded.
Well, I disagree because.
Explain that to me.
Well, because number
you're
one,
running the defense. Or
Well,
your client is running the defense.
no, a lawyer who's representing the insured is running the defense.
Yeah,
So-
and that lawyer is being paid by the insurance company.
Right, whether or not Vermont Mutual selected that lawyer or the insured selected that lawyer, Vermont Mutual had the duty to defend and did pay for those attorney's fees. And that attorney is working for the insured and representing the insured. And that's their sole interest, really, is to protect the insured. So I disagree with that suggestion. And then it runs back to the policy language. The policy language, I suggest to you, makes clear that there's only one time when those attorney's fees are going to be covered. And that's not the case here. So I recognize your point, but I don't think that changes the language of the policy and the rules of construction in interpreting the policy. And those rules are clear that we have to look at the entire text of the policy, the whole text construction.
And then just
requirement.
one more factual
Sure.
question. Who decided to appeal?
I think it was a joint decision. Once again, the insurance company, this is probably beyond the record at this point in time. So I speak with some concern. But I think the insurance companies agreed to pay for it. The lawyer, the insurance company selected a lawyer that the insured agreed to, and that lawyer pursued the appeal. And there was an interesting battle in the appeals court as to whether or not the judgment could stand. And I think it was a close call. But Vermont paid for it, and the insured was represented by counsel representing the insured.
Okay, thank you.
When you take your average insured, as we're trying to figure out what the language means here, isn't the average insured going to think that they are that the insurance company is going to cover any damages that are paid because of bodily injury? And that would include attorney's fees?
If the average insured stopped reading in the first line of the policy, maybe the average insured could say, gee, I'm not really sure what that means, damages because of bodily injury. But the average insured can't stop reading after they find something that they're not sure what it means. The construction requires that the entirety of the policy be considered. And when you turn the page and go to RA 70, I suggest to you it's crystal clear that there's only one instance that attorney's fees of another party are going to be covered, and that's the insured contract exception. And the rules of construction require that not be read out of the policy. So essentially, if we're going to say we can stop, create some ambiguity because we stopped, say, gee, I can interpret those 5 words differently than the technical sense that those words were intended. Now you have read out that section of the policy. You've also made superfluous the coverage separately provided for loss of consortium, again, tied to the damages because of bodily injury language that presumably the average insured stopped reading after on the same page. Damages because of bodily injury include damages claimed by any person or organization for the care, loss of services, or death resulting from a bodily injury. There's no reason for that language if a broad interpretation beyond the technical use of the terms, damages because of bodily injury, there's no reason for that to be there either. So now we've made 2 provisions superfluous. I suggest to you the drafters of the policy understand this court and other courts when they say the policy as a whole will be construed, technical terms will be given their technical meaning. And in 116 condominium trust, the court made clear that damages does not include the damages. I'm confusing my cases, but the 116 case made a pronouncement as to what damages are, and damages describe the payment made to compensate a person for injury suffered. Here, the attorney's fees aren't tied to any injury suffered. The attorney's fees aren't even.
They are, right? I mean, if there weren't I didn't find your but-for thing very persuasive. I mean, if there wasn't an injury, there wouldn't be recovery, right? I mean, I understand 93A provides us another way of getting there, but but for her being hurt by the chemicals put in the house, she wouldn't have attorney's fees either, right? There wouldn't be attorney's fees imposed either, right?
I'm talking about the attorney's fee award here, though. The attorney's fee award here is not in any way tied to her injury or to her damages or to her attorney's fee. We're using the Linthicum factor. There's no evidence that as to what her attorney's fee are. So that's not compensation to her.
Is that, I mean, I understand that 93A divides attorney's fees from the damages, but in here, there's a tort claim that disappears or a breach of warranty claim that disappears, right? I mean, I don't understand exactly why it goes out of the case, but absent the breach of warranty, there wouldn't be a 93A violation and there wouldn't be attorney's fees, right?
Correct.
Right.
But I guess my point is,
I'm not saying you're wrong on your other argument that the way the policy is written precludes attorney's fees, except for in this very limited situation, but I don't find the but for or the because all that compelling.
I think my point, Your Honor, is very simply that if damages are intended to compensate a party for an injury suffered, the attorney's fee award here is not intended because it's not even tied to what she is charged as an attorney's fee. It's completely divorced from what she is charged as an attorney's fee because we don't even ask what she is charged as an attorney fee. We go through the Linthicum factors and we come up with a reasonable fee and never look at what she is charged. And the reason is because under 93A, there's a policy that the prevailing party received the reasonable fee in order to encourage others to to prosecute such violations. And I don't want to say private attorney general, but that's how you get the cases pursued. But it's not tied to the injury. So when
But I mean, it is tied to the injury because we encourage people to bring the suits so that the injuries are punished, right? The unfair and deceptive acts are punished.
well,
And I mean, I understand that it's 2 or 3 steps removed, but it all arises out of the fact that there's an injury, doesn't it?
arises out of is an interesting choice of words because that's not the
I
causation.
understand the insurance industry has a difference between because and arising out of.
Well, and I think that when the policy has arising out of in several exclusions, and then because of here, and we know the Supreme Court has said because of is but for, there has to be a distinction between those words. And I suggest to you that's part of the problem with the Neil Pettit decision was they said, well, the injuries stem from the bodily injury. Stem from is arising out of. It's not but for, and this is but for language in this insuring agreement. But again, that's focusing just on the 5 words in the insuring agreement. I suggest to you that when you continue reading on and get past those 5 words and read the policy as a whole, it's patently clear that that there's only this one instance when the fees will be covered.
Well,
And
what you're going to hear when the police stand up and say, you have the pen, you could have added this to the exclusion.
But we don't want to exclude coverage in all circumstances. We want to provide coverage when there is an indemnity obligation that the insurance company has to, that the insured has to pay. So I heard that argument before. I saw the judge made the suggestion. We don't want to exclude attorney's fees under those circumstances, and all same thing in the definition section. But now the insured who's looking at the contractual liability coverage has to look somewhere else to figure out if they've got coverage for this because the contractual liability exclusion doesn't tell them. So alternatives doesn't change the fact that the policy as a whole has to be considered here.
Can you walk
there's always
us,
alternatives.
could you walk us through, can you walk me through that language, the solely for the person? Because I find it, I'm trying to make sure it doesn't serve something else too.
Sure.
So I'm looking at page 17. I can't remember if it's your brief or the other brief, but where the language solely for the purposes of liability assumed in an insured contract,
Yes.
that reasonable attorney's fees and necessary litigation expenses incurred by or for a party other than the insured are deemed to be damages because of, is there a subtle purpose to that besides? Because it makes sure there's more damage, there's more money available to pay for bodily injury. Does it have some particular purpose? Because he's going to get up and tell me that has a little different meaning than you do. So I want to give you an opportunity to.
Sure,
Tell
Your
us
Honor, I
everything
think
about
if you go back one page to RA 69, okay, and this is getting into the weeds, but if a indemnity of the insured says, hey, I'm entitled to indemnification, and the insurance company says, yep, you are, we have an obligation to pay for your attorney's fees, but we can do it with one attorney if everybody agrees that there's no conflict. Under those circumstances, it's not going to be damages because of bodily injury because it takes away from the policy limit that's available to indemnify for the claim. Then it's going to be just determined to be a supplementary payment. When those circumstances don't apply, then it's going to be subsumed within the policy limit. But it shows you that there's a lot of thought that went into this. This is not just an insurance company saying, yeah, we're going to define it this way, this way. They're going through the various circumstances because they know that there are going to be various ways that this is presented to them. And if they can have one lawyer represent everybody with everybody's consent, then why should we have to go after the policy limits when we have a duty to defend anyway? I see my time is running out, but I'd like to address briefly, unless there's any other questions on this.
Don't leave that yet, because I have a feeling that this case may come down to the meaning of that and whether it has two different, and I don't fully get it yet. So in a normal case, so we're dealing with these indemnification agreements, and and making sure that the amount of money paid for attorney's fees is not subtracted from the amount available, right?
If there's a joint defense.
Right.
With one lawyer.
And does that suggest that in another context, that the attorney's fees are covered, but they do subtract from bodily injury?
Exactly. So if they can't be a joint defense.
So it's I don't think you mean what I obviously you can't figure out what I'm thinking, but what I'm worried about is that he's going to stand up and say, no, it just means they are covered, but they subtract the amount available.
Well, I think you have to read the entirety of page 68, 69, and 70 to see how this is dealt with. But when there's a joint defense, because there's no conflict and one lawyer can represent everybody, it does not subtract from the limits. If there can't be a joint defense or somebody doesn't agree to a joint defense, then damages because of bodily injury will include the attorney's fees of the indemnity, the one time as it's explained, and those attorney's fees will be subject to the policy.
But I'm wondering if he's going to stand up and argue that, yeah, okay, here, that's how it works. But in a normal case, you still get attorney's fees. It's still recovered. It's part of the total amount you can recover.
Well, he may argue that, but in the end, we're talking about policy limits and what's going to be covered subject to those limits or not. And if we run through the policy limits on the underlying case and we still have attorney's fees from the indemnity, it's unfortunate that a joint defense wasn't provided. But again, this is what the insurance company was trying to address, which again, I suggest to you, whether they could have done it in a different way, whether there's alternatives, you can see as you go through 68, 79, 69, and 70 that a lot of thought went into this, and a very clear only in one circumstance. And I suggest to you, you can't find ambiguity just because you stop reading. And that's what happened. That's what I suggested is here. If I could just address the question of costs briefly, Justice Wendell, you wrote an opinion in the appeals court, the Styler decision. And I suggest to you, there's a footnote at the end of Styler that says that we're not necessarily saying that our analysis here will apply if there's coverage for the underlying case. I suggest to you the analysis is spot on. Technical terms are entitled to a technical meaning. They have offered a fallback based upon Idaho that Massachusetts rejected in Styler. And again, the decision in Styler reinforces that you have to look at the entirety of the text. When a technical meaning, a technical word like damages is used or cost taxed is used, it has to have the technical meaning. Same I suggest to you between arising out of and because of, and you can't interpret the policies, or they are not to be interpreted in a way that makes parts superfluous when there's a approach that gives a harmonious meaning for all of the provisions of the policy. Unless there's any other questions from the panel, I rest on my brief and I thank you for your time.
Thank you. Okay, Attorney Wickstrom.
May it please the court, Timothy Wickstrom, I represent Phyllis Maston. With me here today is Deborah Gresco Blackburn. Judge Tutman had it right. She wrote a very cogent, credible, insightful decision. And she began by looking at the standard and recognizing that we look at this interpretation of the insurance policy from the position of the reasonable person in the insured's position, who would understand the phrase sums that the insured becomes legally obligated to pay as damages because of bodily injury to encompass coverage for attorney's fees awarded in connection with a judgment that the insured had been dragged through and that a judge had found a breach of warranty that resulted in bodily injury. Take a step back. If you're the insured and you go through the trial and there's an award against you for bodily injury and for attorney's fees, that reasonable insured would believe under that definition, sums that the insured becomes legally obligated to pay as damages would include and encompass the attorney's fee award.
So now can I ask you to address the exclusion to the exclusion?
Yes.
Yeah, why isn't the reasonable insured tagged with reading through the whole document and coming to page RA 70 and saying, well, gosh, solely for the purposes of liability assumed in an insured contract, does the term or the phrase damages because of bodily injury include attorney's fees? Why isn't that enough to put the reasonable insured on notice that when we're using the phrase because of bodily injury everywhere else, we're not talking about reasonable attorney's fees except in this exception to the exception?
Because first of all, that exclusion has got nothing to do with the set of facts in this case. It involves an indemnity agreement between the insured and a third party. There's a contractual agreement for liability. And so under those circumstances, the coverage is going to be afforded to the defense of that case, not to pay an award of attorney's fees to the plaintiff, that which we have in this case. That goes to the defense fees. That's all it's trying to protect here, is the control of the defense by the insurer on this indemnity agreement. It's got nothing to do with an award of attorney's fees to the plaintiff.
But again, reasonable insurer says solely in this context, do we deal with attorney's fees, essentially? I mean, I understand that there may be complexity and subtlety and sort of how you account for these things, but it's like a big, bright, flashing light saying, oh, you get attorney's fees solely for these purposes. It doesn't it? I mean, that's solely for the benefit. That language is sort of striking, right? We can't ignore it. You can't just say it applies to something else when it says solely in this other context, do you get attorney's fees?
But it's such a different set of circumstances, Your Honor, that doesn't apply to this case. The exclusion has to do with this indemnity situation. And they want to control the defense of the case. It's got nothing to do with paying the award of damages in the case. Damages here, as found by Judge Tutman, would include attorney's fees because the reasonable insured, having now got a sum of money that he's legally obligated to pay as damages, believes that damages would include the attorney's fees.
So the Wisconsin case, the Wisconsin State School District of Shorewood makes the opposite point, that it's clear as can be that attorney's fees are not damages because of bodily injury. They're just not the type of damages that exist because of bodily injury. And they just take the opposite view of what the words mean. And it's not stemming from like the Ohio case. It's not arising out of, are these attorney's fees because of a bodily injury?
The whole case, underlying case, involved bodily injury that a judge found as a result of a breach of warranty claim. So I don't think there's any dispute that the damages were because of bodily injury.
No,
There's no dispute about that. It's whether or not attorney's fees are part of the damages,
Right.
and whether they're covered. And with respect to that, I would point out that there is no definition of damages in the policy, that there's no exclusion excluding attorney's fees. One simple sentence of this policy does not provide coverage for attorney's fees would do it. That does not appear in the policy. So there's no definition of damages. So there's no definition
Can I ask,
excluding
this
damages.
is a standard policy, right? These are, is this one of these standard form insurances policies?
Yes,
So it applies throughout the country, right?
yes.
That's where it gets me nervous. So bear with me for a second. 93A is one of these rare attorney fee creation statutes. Normally in torts and contracts, normally in tort cases, you pay for yourself, right? So we've got this provision that's written for the entire country that doesn't have 93A, and now we're applying it here. So don't we have to sort of sort through that a little bit? Because again, a breach of warranty case, you don't usually get attorney's fees, right? The American rule applies. The same thing with a tort case. So here we've got Massachusetts, we've got this particular 93A attorney fee provision that's, idiosyncratic, and we're applying it to these nationwide forms, right?
Yes, Your Honor. So a couple of points to make in response to that question. First, the issue here is not whether attorney's fees are treated differently from other damages under 93A. So it's not an analysis of attorney's fees under 93A. It rather is whether attorney's fees are covered under the policy language. So Judge Tutman makes that distinction. I believe it's a good one to make. That's number one. Number two, the insurance industry.
We're not saying, we have to interpret this language. This is, it's unusual, right? We got, are there any, besides this one case that we've found in Ohio, is there any other court in the country that's done this, found attorney's fees covered by bodily injury?
Not exactly under these set of facts.
Well, but these set of facts are pretty common, a breach of warranty or a tort, right? I mean, that's, most of these policies cover this kind of stuff. So this is a fairly radical shift in the law.
I would not suggest that, Your Honor. And it's one that the insurance industry saw coming. In my brief, I cite to an article that was written in the Insurance Law Journal back in 2014, in March of 2014, for the defense. This is an insurance article talking about this language that appeared in the Pettit case. And they conclude, in addition, the insurer would be well advised to adopt a belt and suspenders approach and make clear, number one, in the insuring agreement, that's the part that says we will pay, in the insuring agreement's coverage grant, that an award of attorney's fees is not covered, and in the definition section that the terms loss, damages, and money damages do not include an award of attorney's fees. They're saying that right here in 2014, watch out. Pettit is out there. Make a decision. Go change your policy. So with respect to this coming out of left field, it's not coming out of left field to the insurance industry.
Pettit is the Ohio case. So we've got a case by the Ohio Supreme Court that takes a surprising, creates a surprising result. And the insurance companies are saying, oh, we got to watch out for this. This could happen again.
Change the policy. That's what they're suggesting, because there was an award of attorney's fees under the insuring agreement as found by the Ohio Supreme Court. They didn't change it. Excuse me. They didn't change it. They didn't modify the definition of damages, which they could have done.
He's arguing the reason they didn't change it is because they have a lot of indemnification agreements and they want to have the attorney's fees covered there because of the way it interacts with the coverage amounts, I think. But again, all these things are somewhat impenetrable until you read them 25 times.
It really is apples and oranges, Judge, because the
It can't be
exclusion deals
apples.
with
The problem is
with
it just
defense.
says solely for these reasons. So that makes it harder for us to say that's just over there. We can't just ignore that solely language. Because they could just say in indemnification agreements, this is how this works, right? They could have written it that way if they could have simplified that.
They could have modified the exclusion if they wanted to modify the other one as well. Yes, they could have done that.
But it would have been much better for you had they done it that way. They didn't do it that way.
I think it's still good for me as we have it here today and as Judge Tuckman found in her decision. You know,
Can
with
I ask you a
respect,
factual question? When was this policy issued?
it was issued back in 1998, I believe.
And what you read to me was from 2014,
That's right,
and Pettit was somewhere in between.
2010, I
Okay.
believe.
This policy is written 12 years before Pettit.
Yes,
So you can't quite you can't fix something that happened before it.
no, but you can fix it going forward, and they didn't do that.
I mean,
And no one has done that.
What do you mean by that?
There's
There's been no
to-
edit to the standard form?
There's no change, to my knowledge, of the insuring agreement that we're talking about here today from 2014 to today. That part of the policy that says we will pay those sums that the insured becomes legally obligated to pay as damages because of bodily injury. I would like to address an unfairness, injustice. If you think about the procedural posture, at least part of the attorney's fees that I think Your Honor was addressing early in this argument, that being when the underlying case was appealed to the appeals court, well, there were attorney's fees for the appeal. Those were awarded to the plaintiff. Those were not paid by Vermont Mutual either. In a situation where Vermont Mutual had a duty to defend and a duty to indemnify, the plaintiff, the defendants, their insureds were on the hook for the appeals court fees. How unfair is that? What kind of the amicus brief
I'm not
speaks
sure I
with
follow.
public
So-
policy.
So tell me, you better flesh that out a little bit. So they have a duty to defend.
Right,
They think they shouldn't be paying, so they appeal. Aren't they?
after the appeal, which we won below
Right.
appeals court, the appeals court awarded attorney's fees to the plaintiff.
They award attorney's fees to the plaintiff because it's a 93A action.
Right.
So it's not there's no frivolous standard. You win 93A, you get the attorney's fees, right?
Right,
So they're between a rock and a hard place, right? Either not appeal or expose themselves to attorney's fees, right?
expose their insureds, which they're not paying those appellate fees to the plaintiff. Those are in addition to the awarded attorney's fees below. How unfair is that?
Just create all the complexities of 93A attorney's fees, which probably no one ever thought about when they created this sort of extra remedy for everybody.
Okay, if there are no further questions. Well, thank you, and we'll take our morning break.
Thank you.